date is started was 2nd of 89 of 2016.
What do you have to submit on password with this limitation?
Yes, I'll just come to this. Just allow me to show certain provisions and then things will flow. One is your lordship will see section 81 of the same. Limitation words, if I have an objection regarding limitation of their appeal as well. The appeal which was filed, the delay was never condoned, so any kind of
Now the substantial question of law has been
still, that is again a question of law which I can also substitute that if your lordship is considering to allow the appeal because the appeal itself was not maintainable. That's a question your lordship will have to decide because the appeal delay was not condoned. And till the time delay is condoned, the jurisdiction of the appellate court was wrongly assumed in marking it. But I don't want to get into that. My simple answer is that the full bench of the Patna High Court has said, so far as this 3 months is concerned, saying that the 3 months cannot mean that after 3 months, if your lordship interprets that the title has been decided.
We will not interpret anything.
That has already been
You
interpreted.
see, that has already been interpreted. We need not pronounce on that.
Correct. My answer.
Our only concern is whether the petition which was filed after a considerable delay of around 7 years or 10 years was it maintainable, and coupled with the fact that whether limitation section 5 was active.
That's the second question is if it is applicable or not, then this is the first question. But again, therefore I was saying, you will then also have to decide with the appeal in order to allow the appeal on that ground whether the appeal itself was maintained.
No, appeal at the appellate stage, the delay was condoned.
Not condoned. The appeal's delay was not condoned. That's what we have to understand. In fact, the appellate court noted that there is no condonation application. So therefore, if your lordships allow this appeal, that means his appeal before the trial first appellate court is allowed. So if that appeal is ineligible, today it can't be made eligible by virtue of time. So that question also arises. They will have to answer that how their appeal, because from the records it says the memo of appeal is filed in order and correctly stamped, but filed after 2874 days beyond the period of limitation. No petition for condonation of delay has been filed, and there is nothing on record which shows that the delay was ever condoned by any order.
So appeal was entertained without condonation.
Without condonation. So today also there's any order on this appeal which has the effect of allowing the appeal will be without jurisdiction. That is one. Number two, while it is true that section 87 prescribes a period of 3 months to file an application.
You see, we will confine ourselves only to the point of law which has been made.
No, but I am therefore I can also raise a question at the time of final hearing. But this is not an appeal under section 100 of the CPC strictly. This is not an appeal under section 100.
That's right.
It's an appeal under section 87 itself.
Where is the record of the appellate court?
Appellate court.
Where is it mentioned that it is delayed?
Well, in the memo, when there is a stamp office report, kindly take the memo of appeal, the back side of the first page, there is an office report over the Saristara. Yes, yes, ma'am, that. The second part you also will see is computation of limitation is there 2874, then there is a reporting. So therefore, no order on this, my lords, appeal, memo of appeal can be passed, could have been passed either by the first appellate court or by your lordships, my lords, without condoning the delay, which has not happened.
They did not file any petition for
No, that is what the report says. They did not file.
And what is the period of limitation?
30 days. No? According to the reports of 30 days, and according to the Act Section 87 also, it's 30 days. Rule 76. Rule 75(2) prescribes the period of appeal, period of limitation for appeal.
Would you have to say that your appeal was also barred by limitation?
Does it kindly have that record? The lower court record.
It was condoned. By which order? It is condoned.
I missed that. I'm just. My friend was very confident.
आपको जो बोला वही है subject to corrections. तुम तो अपने
I'm very sorry.
Now you tell us.
Now let's come
Now,
to
one more thing.
Yes.
Before we proceed. You see, we can understand that there could be a suit. We do not know what is the contour and the nature of the suit. Let's assume it for a moment. If we ultimately hold that prima facie I am satisfied with him, that I am disclosing, that the section 5 was not applicable, then under such circumstances the order would go.
yes.
And then I will leave it to the parties to proceed as per law.
There is no dispute. If you
That is all. Nothing more.
No,
I
nothing.
will, once I decide that the petition was not maintainable
Absolutely. I will
on
satisfy.
account
I
of being
will
barred.
satisfy that
If you are
section 5 is
satisfied,
maintainable. Now we were all looking for a judgment which your lordship's courtmaster only has been kind enough to get a print for your lordship's. Is that 63 PLJ? Unfortunately, I don't have a copy, but this says that section 5 applies to CNT Act unless it is inconsistent. I will show there is nothing inconsistent in section 87 to oust section 5, applicability of section 5,
you see, all provisions of Indian Limitation Act would apply,
including section 5.
including section 5.
Yes, ma'am.
Fair enough. But the point is that when it is a initial jurisdiction, like section 5 is not applicable to a suit.
No, it is not.
Not applicable.
It is not a.
So section 5 will not apply to the suit here also.
It is not a suit for the purposes of the word suit has been used, but it is not a suit for the purpose of Limitation Act. I will make good of that.
Otherwise, you see what is going to happen. That the proceeding under section 87 etc. will not terminate at any point of time. You can have parallel proceeding. One is suit is filed after 3 years or maybe after 12 years for adverse possession, etc. Then you will have a parallel proceeding under CNT Act.
As the
Right?
scope is-
And when the law provides specifically that this much time is granted and there is no further relaxation, then under such, and it is specifically referring to a suit, and a suit of such a nature where the second appeal is lying before this court. Maybe it is not stricto sensus in the but still substantial question of law is being framed here.
No, that's not
That has been framed over here.
that has been framed because the rules which are the procedure prescribed by the rules completely show that it is more rule 70. Rule 50. Now, can I just answer this? How 3 months is? What is the effect of 3 months? 3 months is not from the date of publication of the record. You kindly take section. Allow me to place few provisions of the CNT Act and
First
they are-
you place this judgment.
This judgment will merely say that section 5, if it is not inconsistent with the provisions of the CNT Act and will apply to all proceedings. But your Lordship's question is different. Your Lordship is saying that if it is a suit, then in any ways it will not apply. Had it been an application, appeal, etc., section 5 would have applied. But it's a pertinent question and I will answer that.
Just what do you want to say?
Yes. Now, just have a look at few provisions and I will go back to section 87. Now, kindly come to the beginning of chapter 12 of the CNT Act, Record of Rights and Settlement of Rights, which is of which section 87 is a part. Lordship, so that the scope is clear. Section 80 talks about power to order survey and preparation of record of rights.
Section 87.
80
Section-
of the CNT. Right, this is chapter 12. Power to order survey and preparation of record of rights. This is state government has the power to order survey. Kindly skip that. Now 81 is important. what are the particulars to be recorded? Where an order is made under section 80, the particulars to be recorded shall be specified in the order and may include either without or in addition to other particulars some or all of the following. Namely, there are things given. I may not read everything. I have a different reason why I am indicating that there are from A to N certain particulars which are to be entered in the record of rights. This is the entries of records of right. Very well. Then there is a provision of section 83 which talks about draft publication, preliminary publication, then you should skip minutes and straight away come to 87. In a proceeding under this chapter, a suit may be instituted before revenue officer at any time within 3 months from the date of certificate of the final publication of the record of rights under subsection 2 of section 83 of the decision of any dispute regarding any entry which a revenue officer has made in or any omission which he has made from the record except an entry of fair rent settled under the provisions of section 85 before publication of the record of rights, whether such dispute be A, B, C, D, including title. So the scope of section 87 suit is only with respect to the entry made in the record of rights. It actually does not, the reference to a title dispute does not mean the title between the parties can be decided by a revenue court.
That's right.
Correct, Manoj? So the scope of section 87 is very limited only with respect to the entry made. And I have shown what are the entries. In that, incidentally, if a dispute of title, but that's not an adjudication of title.
That's right.
Now the limitation will start if after a certificate for final publication is prepared under subsection 2 of section 83. Now this certificate is in terms of rule 58 of the CMT. It's not a formality, it's not an empty formality.
Why do you want me to go into all this? From
Because
where
of-
will you show that these rules were not complied?
No, the question is not then they have to show that the record of rights were there has to be shown that there was
Whatever
distribution.
there is in the record, we will only see that. There was a dispute raised in connection with entry in record. A petition was filed under section 5. Do you want to say that since these proceedings were not followed, therefore there was no cause of action?
I'm just trying to explain one that the delay, we cannot read 3 months. 3 months is within. 3 months is within from the date of certificate. So the cause of action arises from the certificate.
So certificate has not been issued.
According to me, Rule 58 was not complied with.
If not complied, there is no cause of action.
Number one. But if I have come to know,
Yes.
then I can explain that this is not a hard and fast rule that you will not be
You
entertained.
can't have it like this. You challenge, it was your petition,
Madam,
you filed it, and then you say that these were not complied and therefore there is no cause of action. You can't have it this
I'm
way.
saying if it has come to my knowledge,
Yes.
and then if I choose to apply, then there should not be a bar in me applying. That's my argument, number one. Number two, the Limitation Act inapplicability of section 5 will only happen if it's a suit. And suit mirrors kindly now have the Limitation Act and the CPC. I will show that the suit in the context only means suit before a civil court and not suit before a revenue court.
It is a limited suit relating to entry in record of rights.
Correct, but it can't. So the use of the word suit may not make it a suit for the purpose of Limitation Act section 3. Kindly have section 3.
Suit has been defined under CPC.
No, suit has not been.
Defined in CPC.
But I will show me that a suit before a revenue officer is not a suit under the CPC. Can I just request that your lordships to come since CPC is there?
Yes.
Kindly take section 4. sorry, section 5. These are two different things. Section 5 2 very clearly makes it evident. Section 5, application of the code to revenue courts. Where any revenue courts are governed by the provisions of this code in those matters of procedure upon which special enactment applicable to them is silent, the state government may by notification in the official gazette declare that any portions of those provisions which are not expressly made applicable by this code shall not apply to those courts or shall apply to them with such modifications as the state government may prescribe. So as a general rule, if it is silent, CPC will prevail unless excluded. 2. Revenue courts in subsection 1 means a court having jurisdiction under any local law to entertain suits or other proceedings relating to rent, revenue or profit of lands used for agriculture, but does not include a civil court having original jurisdiction under this code to try such suits or proceedings as being suits or proceedings of a civil nature. So therefore the suit before a revenue court is not a suit under CPC. And what is civil nature has been defined by section 9. Section 9. Explanation 1.
Yes.
The explanation 1 says, a suit in which a right to property or to an office is contested is a suit of civil nature, notwithstanding such right may depend on. So right to property is always a civil nature. My submission is therefore a suit on the CPC must be a suit with respect to civil nature, and a suit under section 87 is confined to record of rights entry. Therefore it is not a suit under the CPC, and therefore hence section 3 Limitation Act will not apply. Once 3 does not apply, it becomes an application. Though the word used is suit, section 5 will automatically apply in view of section 230 of the CNT. Huh? 230. Yes, 230 of the CNT Act. Now the question which will then arise, even if my submissions are accepted, is that whether in view of the words used within 3 months, section 5 will apply. The answer is in one of the judgments of the Supreme Court Lordships have followed, Union of India versus Popular Fans. It was in the context of the Arbitration Act section 34. Now relevant paras are not para 5 to 8.
Yes.
The issue will have to be resolved with reference to the language used in section 29(2) of the Limitation Act and section 34 of the 1996 Act. Section 29(2) provides where any special or local law prescribes for any suit, appeal or application a period of limitation different from the period prescribed by the schedule, the provisions of section 3 shall apply as if such period were the period prescribed by the schedule, and for the purpose of determining any period of limitation prescribed in any suit, appeal or application by any special law or special or local law, the provisions contained in section 4 to 24 shall apply insofar as and to the extent to which they are not expressly excluded by such special or local law. On an analysis of the section, it is clear that the provisions of section 4 to 24 will apply when 1. There is a special or local law which prescribes a different period of limitation for any suit, appeal or application. The special or local law does not expressly exclude those sections. There is no dispute that the 1996 Act is a special law and that section 34 provides for period of limitation different from that prescribed under the Limitation Act. Then the question is whether such exclusion expressed in section 34 of the Act 1996 Act. The relevant extract of section 34 reads as under. 3. An application for setting aside may not be made after 3 months have elapsed from the date on which the party making an application had received the arbitral award, or if a request has been made under section 33 from the date on which the request has been disposed of by the arbitral. provided that the court is satisfied that the applicant was prevented by sufficient cause from making an application within the set period of 3 months, it may entertain the application within a period of 30 days but not thereafter. Had the proviso to section 34 merely provided for a period within which the court could exercise its discretion, that would not have been sufficient to execute 424 of the Limitation Act, because merely provisions of a period of limitation in howsoever peremptory or imperative language is not sufficient to displace the applicability of section 5. So this is the same answer notes, that it does not exclude. Now your lordship will also note section 29 of the Limitation Act, which I just read, also includes the word suit. It just does not include application or appeal. It also says that if any suit time is provided by a special law, applicability of section 5 will be there, 5 to 24 will be there, unless expressly excluded. Rather, here the CNT Act makes it applicable unless it. So even if it is a suit, therefore, the language has a meaning. A suit strictly under the CPC, section 5 never applies. But a suit under a special law, unless applicability is excluded expressly, section 5 will apply. The purpose is very simple, bro. That this is a revenue. Ultimately, it's a revenue record. There is a presumption of correctness of the entries, but that does not mean. I have got 2 judgments just to show that it is not a reflection on the person's title. It may be an evidence in aid of his title, but not.
What about 238?
238. Yes. Notwithstanding.
Special rule of limitation in certain applications and suit before the revenue officer.
Yes. And this is inserted in the notwithstanding any of the provisions of the Indian Limitation Act, where an applicant subsection 3 of section 85 is made, or a suit under section 87 so and so has been instituted within 3 months from the date of final publication, and any person is thereafter added or substituted as a party to such application or suit, the application of the suit shall, as regards such person, be deemed for the purposes of limitation to have been made or instituted on the date on which it was instituted by the original applicant and the plaintiff. So it's on addition of parties.
What about 231?
Yes. Again, notice all suits or applications instituted or made under this Act for which no period of limitation is provided elsewhere in this Act shall be commenced and made respectively within 1 year. So, like in this case, 3 months have been provided.
230. Can you read it
232
once?
is notes grant of leases.
Can you read 230?
230.
Yes.
The provisions of Indian Limitation Act shall, so far as they are not inconsistent with this Act, shall apply to all suits, appeals and applications. So it says provisions. It does not say that 5 will not apply. Therefore, it will apply if it is not inconsistent. And that is what the judgment of 63 BL that is. Sugosau exactly says what that section 5 will therefore apply. Since it is not a right to since it is a property right, it is not a property right, property rights just one of the entries. I have shown the scope of section 87. The use of the word suit by itself is not determinative of the factor that the section 5 is excluded. Therefore 29(2) also makes it very clear that suit under a special law, section 5 may apply unless expressly excluded, even for the purpose of suit. Or else, if it had to be understood otherwise, the word suit should have been omitted from 29(2). It should only have been applications and appeals. To sum up, my understanding is.
Let's see section 5.
Yes, it's fine. Any appeal or any application other than an application under the provisions of Order 21 of the Code of Civil Procedure may be admitted after the prescribed period if the appellant or the applicant satisfies that the court to the court that he had sufficient cause for not preferring the appeal or making the application in such way. But now kindly read it with section 29 again, let's for a moment, then things will be clear. Section 29(2). Where any special or local law prescribes for any suit, appeal or application a period of limitation different from period prescribed by the schedule, the provisions of section 3 shall apply as if such periods were periods prescribed by the schedule. And for the purposes of determining any period of limitation prescribed for any suit, appeal or application by any special local law, the provisions contained in section 4 to 24 shall apply insofar as to the extent of which they are not expressly excluded by such special. So now by deeming fiction, a suit under a special law is also being brought under the purview of section 5 to 24. What is the purpose of this section? If your Lordship looks at the definition of period of limitation, it will throw more light. What does section 29(2) says? Period of the limitation has been defined by section 2J of the Limitation Act. Period of limitation means the period of limitation prescribed for any suit, appeal or application by the schedule, and the prescribed period means the period of limitation computed in accordance with the provision of the Act. So section 29(2) says that in the schedule there is no time limit given for making an objection to a record of rights. Since the CNT Act provides for 3 months, that will form a part of the schedule of the.
There, your argument that the term suit,
Yes.
which has been used in Total Tenancy Act for the purposes of section 87, is by all means an application.
Yes. It may be a suit, but it is not a suit under the CPC.
You see, the Limitation Act also contemplates that there can be a suit under different laws.
That's what I'm saying.
Under revenue law.
Let me take that. I am saying if that is the point, the only section 3 bars, the applicability of section 5 is not there where it is a suit under the CPC. Any other suit under special law also, it has been brought under the purview of section 29(2). That's what I'm saying. So the point is, no authority other than the original authority of a civil court can be extinguished. It is not. There is no right which can be extinguished permanently so far as other laws are concerned. Ultimately, what is the purpose of period of limitation? What is extinguished is my right to go and challenge a particular act. Right? Now, here, no right is created by an entry in the record of rights, in the property. It is merely an entry which shows that who is in possession, who is going to pay rent. There are n number of judgments by saying that mere entry in the record of rights does not create any right or title in the property. It's only an administrative document which helps the government realize the rent. Therefore, no one's right to challenge can be extinguished. If there is no right, there is no right to be extinguished. Hence, the application of section 5, because these are ministerial in nature.
So you have referred to, I'll just note which all sections you have referred. You have referred to section.
Can I just sum up? I'll
Yes.
give it the way your Lordship wants. In the Limitation Act, I have referred to section 2J, and I want your Lordships to see section 3, so that is very, very clear that what it wants to say. 2J3, section 5 of the Limitation Act, and section 29(2) of the Limitation Act.
You should read suit also.
I'm coming. Now, suit
2L.
2L suit does not include an appeal, right? Yes, you're grateful. Lordship will read 2L. Suit does not include appeal. Now, in the CPC, I have referred to section 5, specifically section 5(2), and section 9, explanation 1. Section 5.
Explanation 1.
Section 5, subsection 2, and section 9, explanation 1, to show that a suit before a revenue court is different from a suit before the civil court. Because property rights.
See, if the Limitation Act is applicable to the suits filed under the revenue codes by virtue of section 29(2), then under such circumstances, the suit having not been defined under the CNT Act and defined under the Limitation Act, which includes suit does not include
Correct.
an appeal or an application.
Correct.
So your argument that this suit has to be treated as an application.
No, I'm
is
taking back. I'm saying that even your objection is right. I may have not been correct in that. Even if it is a suit under the special law, then also by virtue of section 29(2), the provisions of section 5 will apply.
That is a separate.
Yes.
That
That's
is
the
a
argument.
distinct argument.
That's the argument I propose to make. Your lordship is right in indicating the suit. Then I will not succeed. Suit excludes.
Then under such circumstances, if a suit which is filed under the revenue code so you want to say that the suit under section 3 of under the provisions of CPC,
Yes.
this section 5 may not apply,
Yes.
but for the suit
Under
in the
special-
revenue code under
Yes.
special law, this provision of section 4 to 24
will apply unless expressly excluded.
unless expressly excluded.
Because section 29(2) clearly says that this will apply to suit, appeal and application. We cannot, because the law of interpretation is that a word used in a statute is not superfluous. Every word has to be given some meaning. If the legislature has used the word section 29(2) suit, that means that it intends to cover a suit under a special law by section 5 to 24.
And then you refer to
Yes, section then CNT Act means I refer to section 230. Section 230, which makes the CNT the Limitation Act expressly applicable to CNT Act 230, and the judgment of this 230 is the Limitation Act will apply.
It says that the Limitation Act would apply to all suits, appeals and applications. So when it clearly says that it applies to all suits, appeals and application, then there is no need to refer to section 29 at all.
29(2) makes the Limitation Act applicable.
Yes.
I'm saying 29(2) or these notes it will apply. All the
It will apply,
provisions. It
right.
will apply. So both
So
together.
if the Limitation Act has to apply to all suits, appeals and application under CNT Act, and if the Limitation Act does not apply to suits, limitation section 5
Section 5.
does
But
not
therefore
apply.
29(2) I am referring to. Therefore 29(2) is also important. So the harmonious construction of 230 and 29(2) will make. Now here also your lordship will see if the legislator intended exclusion of section 5, then it would have said that section 5 will not apply to suit except provisions of section 5 to 24 to suits. Again there is no express exclusion. So by virtue of 230 it applies. Section 29(2) again also supports it unless expressly excluded. So if the legislature intended inapplicability, it would have spelled it out. That's my submission.
And this is only in connection with applications. We cannot read applications and suit interchangeably.
No, your lordship will not.
So therefore this judgment may not come to your
It
rescue.
only, yes, but this question may not have directly fallen for consideration, but your lordship will recall last time we were all looking for this judgment.
Yes.
I am therefore relying upon only on popular Union of India versus popular construction,
That's right.
which says that that's what the correct interpretation 29(2), and this still holds good. Therefore, in my respectful submission, my application, although belated, was maintainable. And just to rephrase what I was trying to say is that a Limitation Act, what it does is takes away a person's right to approach a court against a particular. It does not. It extinguishes the remedies.
That's right.
That's what. Now it extinguishes the remedies to enforce a right. since entries in the record of rights do not create any right in favor of anyone, his right, he doesn't have a vested right in the property
It
because
does
of
not create title,
That
but you
title-
cannot say it does not create any right in favor of anybody.
right in the property.
Right? Entry in record of right could be a cause of action for the purposes of claiming adverse possession.
That is, yes.
So therefore you cannot say that all rights are extinguished or it has got nothing to do with any of the right.
Right, not property right. Some kind of possession, incidental right to the
Whatever be
property.
the right.
Incidental right.
Whatever be the right.
Because
Maybe it does not create a title.
What
You
I'm
cannot say it does not create any right.
what I'm trying to say is, merely by virtue of the entry in the record of rights, no one can defend a title suit if otherwise he or she does not have possession. That I have an entry in the record. That's what the distinction is. That is what the judgment, the full bench says. That you will not, the title will not devolve upon you only by virtue of that entry. It yes certainly creates a right who will pay the right to parent, and these are the judgments minutes on this point.
Do we really need it?
If in case your lordship wishes to address it. Para 8, just one. My learned friend also knows because we just did a case before the division bench. I had cited this. In case of Suraj Khan versus Financial Commissioner, it is observed and held by the court that the entry in revenue records does not confer title on a person whose name appears in record of rights. Entries of revenue records or Jamabandi only have fiscal purposes. That is payment of land revenue, and no ownership is conferred on the basis of such entries. It is further observed that so far as title of the property can only be decided upon. Hence, to say that an entry which is basically for the purpose of revenue, the section 5 will not apply, and within 3 months if it is not done, it will hold good.
You see, Chota Nagpur Tenancy Act has its own nuances.
No, sir.
It
In this
cannot
matter,
be
it does
really
not.
guided completely by the general law.
No, it does not. So far as this is concerned, it does not. Chota Nagpur Tenancy Act is just a tenancy act like Bihar Tenancy Act, Santhal Pargana Tenancy Act, West Bengal Tenancy Act. All these tenancy act amendments have decided there are parts of it. There is certain protection given to a special category. That's a different thing. To that extent, it's a beneficial lay. Now, if your lordship also looks at the constitution, I'll make good of that. In the 9th schedule, let me just check if I'm right or wrong in saying that. Now, kindly, in the 9th schedule, in terms of Article 31 minutes, the protection is not to the entire CNT Act. The protection is only to a particular provisions of the CNT Act, which are beneficial. Therefore, CNT Act for these purposes are just like General Tenancy Act. Entry is there, Santhal Pargana CNT Act. So far as it relates to tribal rights, yes, it is special. It has to be protected. But general, this applies to every kind of person. So in an area, what the Britishers did was, having regard to the nature of the people living there, they enacted different kinds of revenue laws, customized. So CNT Act for all practical purposes is at par with every other law. For this purpose, this has no distinction with tribal rights or any protection given to any person.
This is so far as first question.
Yes.
What about the other two? Let us see the other two questions. Was there
Whether
any
the court-
material available before the court that title suit is pending? Was there any material available?
It appears not from internal paragraph 5 that the plaint and WS were filed.
Which is not there.
Paragraph 5 of the judgment.
That's right, but it is not there in the records. Whatever
says-
they have received. It is not there.
The list of documents filed were. I have yours.
You have the list of documents.
From the order sheet of. Okay. We had filed this list of documents के साथ attach करके before the appeal. Can I just help you, Lord?
Yes, please.
और कुछ नहीं है appeal का? हाँ?
ये भी है.
हाँ.
देखिए. This is also good.
Friend-
ध्यान से सब वापस ले लीजिए जितना
हाँ.
बचा.
और कुछ मौका है? और सब
Has the court recorded that the parties are the same or the issues are the same?
No, so the court has recorded what it has recorded in paragraph 5 that it was filed proceeding Janak Kumar Singh Radhama, it was ordered the aforesaid name Janak Kumar. Defendant is Rajendra Kumar Chair entitled to sue. Property is the same. It is paragraph 5.
The other documents, namely plaint and written statement filed by defendant number 1 in Rajesh Singh Chahal in title suit number 194 of 2015 goes to show that the property involved in the present proceeding is the scheduled property of the title suit and the respondent of the present proceeding is represented by defendant number 1 in the suit where he filed a written statement. And he has specifically stated that he has purchased the suit property from the respondent. So he was claiming through him.
Yes.
Similarly, the appellant and other claimants of the suit property are parties in the title suit number such and such.
And also, with all respect, this question is not a substantial question of law because there is no dispute on this. Merely for the, it is not an academic
Some
question.
material was placed on
Yes,
record.
it was
It
placed
cannot
on
be said that there was no
No
material on
material,
record.
And
that
even
fact.
otherwise, my lords, the fact is a fact. They are not disputing it.
And what is the third question of law?
Third question of law is whether, my lords, it has committed an error by raising a substantial by not deciding the appeal filed. So it has decided, it has not decided. That to that extent, my lords, as I last time said, that by itself, it cannot be said that it has become infructuous. I really don't want to join issues on this.
It doesn't become infructuous,
I
but
am saying
it
it
becomes
does-
subject to the suit.
It become, you should not have said it has become infructuous. So I don't see committed an error of law. It's only record stating it, reiterating the law. Okay, whatever happens will be subject to the result of the suit. Hence, I
So
don't.
ultimately, it should have been said that it is subject to the result of the suit.
Yes.
Because the suit may come out with some finding with regard to title. And then
Even if it does not say it is ultimately subject to the result of the suit, whoever wins in the suit will go with the decree and get his name recorded in the record of rights. So even if nothing happens, it is not said, but it was better that better clarify that.
No point regarding applicability of section 5 of the Limitation Act was raised as such before the first application.
No, it was not.
Yes, what do you have
It is
to
not
say?
yet.
In response, you just quickly
Yes.
sum it.
Well, so far the third question is concerned. Let us come one by one. So far first question is concerned.
Your response to the first question.
Well, yes,
You can
first
also
question is-
refer to the provisions
Yes.
that you are referring to.
Yes. I shall be relying upon section 230, 230 capital A,
230,
capital A, and 231
231.
of the CLT.
Yes.
Was and was the limitation which has been prescribed under section 87. One judgment of the Honorable Division Bench of Patna High Court, which relies upon, was a judgment of 1998 1998. It is मतलब 2004 SCC online Patna.
2004 SCC
SCC online Patna.
But
289. Yes, was a division bench Patna. It relies upon plus 1989 BLJ 41. That judgment I have given to you.
41.
1989 BLJ 41. Or was AIR 1989 Patna 34.
It's the same.
Yes, same.
AIR
AIR 1989 Patna
Patna
34.
34.
Other judgments also no? Your Lordship's compilation
You have given some notes I have seen.
page 25, right. Notes with judgment below
Notes
that
में कौन सा judgment ये लगाए हैं?
page 35.
Page 35. Yes, what is it you are relying
Yes.
on?
This was मतलब with respect to a suit filed before मतलब the Revenue Authority itself under the provisions of मतलब Bihar Tenancy Act. There was 106 institution of suit before revenue officer.
That's right.
Here also the question arose whether section 5 will apply with respect to condonation of delay in filing suit under section 106. And it has been answered like this. Para 15 onwards is same very provisions have been dealt with.
Yes.
Para 15 onwards. According to the said provision, if any special or local law, a different period of limitation is prescribed, then what is prescribed in the schedule of the Act with regard to any suit, appeal or application, provision of section 3 of Limitation Act shall apply, as if the said period were the period prescribed under schedule of the Act. It provides that for determining the period of limitation prescribed in any suit, appeal or application by any special or local law, the provision of section 4 to 24 inclusive shall apply only provided they are not expressly excluded by such special or local law. Thus, according to aforesaid provisions, the court has no power to condone the delay on the sufficient ground after expiry of the limitation under section 5 of the Limitation Act. With regard to suits, such power is vested with regard to appeals and applications only. The Bihar Tenancy Act is a local law and a different period of limitation has been provided, which shall be treated to be a period provided under section 3 of the Limitation Act, and the provisions of section 4 to 24 will apply unless expressly excluded by this local law. Then this is with respect to the provisions of that act and para 27.
Yes.
Here it says, para 27. As stated above, the suit is filed under the Act by presentation of applicant on a stamped paper, and the provisions of the civil procedure code are applicable. Here also, we are coming in second appeal, and the provision is very clear. It says it will be as provided under section 100 of the CPC. Appeal provision sorry. Now, second important thing which I wish to mention, that if Lordship sees the order passed by the authority, the appellate court, it does not decide anything. It does not. It simply, so whether section 5 will apply or not, it was my question raised before the appellate authority. He does not decide that aspect at all. And it
No, appellate authority, you did not raise this issue that section 5 will apply or
Yes.
will not apply.
Yes. Kindly see the appellate order. We read that. Kindly see page 15.
That the suit was barred value.
Yes. Every issue.
But the court did not.
Court did not enter into that question.
And straightaway said that a suit is pending.
Suit is pending
Is-
there.
You see, whatever be the as argued by them. I do
But-
not know. We do not have the plain and the written statement for our perusal. It is not available on the record. It seems that something was produced before the court.
Correct.
And then substantial question of law has been framed by indicating that without any material, on the
Let us
face of the
understand
record,
there
it
was a
cannot be
material.
said there was some material was
Yes,
present.
we accept.
Now, if there is any suit, instead of saying infructuous, if it is held that it is subject to the result of the suit,
That will not be correct because of the provisions under section 258. What I say is, if we conjointly read section 87(2) and section 258, if a party has approached, that is what has been decided, kindly allow me to place one judgment, then I'll come to that. Kindly have, again have that. Paritosmati. What does Paritosmati say? Paritosmati says, I'm reading para 16. Para 15 para 15 kindly have para at page 18, second page. I'm not.
yes. The true legal effect.
Para 15. Para 15, should I read? Last line at least. Para 15.
Thus, in absence
Page
of
17, last line. It makes it clear. It also makes it clear that the aforesaid decision or order will have the force or effect of a decree of a civil court in a suit between the parties. It is speaking about the suit under 87. However, if there is no order or decision under sections specified in section 258, including therein section 87, the jurisdiction of the civil court will not be barred. So if there is a suit decided under section 87, 258 bars it. If there is none, then suit will not be barred. It will not be barred, and especially so in a suit for declaration of title and confirmation of possession or recovery of possession. What further calls for notice is the fact that even where section 258 would be attracted, the bar is not absolute. Then para 16 is important. I'm reading. The true legal effect of a harmonious reading of sections 87 and 258 may therefore be noticed. Chapter 12 provides for the record of right, and section 83 therein deals with preliminary publication. The amendment and the final publication of the record of right, whilst section 84 creates certain rebuttable presumptions in favor of correctness of the entries in the record of rights. However, section 87 provides a remedy by way of a suit before revenue officer for resolving any dispute with regard to such an entry in the record of right or an omission therefrom. In essence, such a suit is thus directed as a challenge to the entry or omission in such record. But section 87 further provides that this can be raised even where such a dispute be with regard to matters specified in clause A to F of section 87. In a way, EE is more title with respect to land also. In a way, therefore, 87 provides a special and additional remedy pertaining to entries in the revenue records as soon as they are finally published and certified. That is why the legislature has chosen to provide a narrow limitation of 3 months from the date of certificate of final publication of the record of right for bringing such a suit. To my mind, this remedy is not in any way in derogation of civil rights of the party, but indeed a special and additional remedy which may be availed of within a limited period of 3 months. If a party feels aggrieved by any of the entries in the record of rights. However, if such a remedy was kindly have. However, if such a remedy is availed of by the party, then a statute now provides an appeal and even a second appeal to the High Court itself in the very forum of subsection 2 of 87, which inevitably would achieve finality. So here it will attain finality. If resort has been made to a suit under section 87, then for identical list 258 would bar a further resort to a civil court except on the grounds of fraud or want of jurisdiction.
Then how do you say that from where do I read that the remedy is identical? From where do I
You know
read
what I
this?
say? Section 87 has been approached by them. Section 87 has been moved
That
by
right,
them.
in 2006.
Now, Lord, Section 87
Suit was filed in 2015.
2050. Now, Lord, Section 87 second proviso provides that if a suit is preferred under a Section 87, then second suit will not lie before the same authority. 258 says if issue is decided before the authority under Section 87, suit shall be barred. So, kindly have 258 once again. Kindly have Section 258 again. If somebody has not approached 87, certainly any suit he can file at any time,
That's right.
subject to 3 years or 12 years. Bar to suits in certain cases. Bar to suits in certain cases. Same as expressly provided in this Act. No suit shall be entertained in any court to
That's why Section 87 is also included.
included. So this is what Pantos Maiti said, that if there is a suit already filed by a party,
Then he has to avail the remedy
Then-
from second appeal till Supreme Court.
up to there you go. I am understanding in this way. If a party fails to avail that remedy, अगर 87 में वो नहीं फाइल किया, then for declaration of title 3 years will be limitation. Within 3 years he has to file a title suit. The Pantos Maiti says that if somebody has not approached the Section 87 authority, then a suit he can file. What is happening here? Instead of 3 years, he spends 10 years and he approaches authority under Section 87. The normal suitor would also have been barred. After he has availed 87, I have gone in appeal because I don't have any other remedy. So taking plea of a suit which has been filed in 2015 between some parties, including them and me, if that suit is taken reference of and the appeal is remaining not decided, is a question. So our contention, my contention is that if 87 would not have been moved, yes, suit would have been the remedy proper and I would have waited for the suit. But here what is happening, 87 he approaches after 10 years and limitation aspect which we raise, the
In
appellate
87
authority
he
does not.
succeeds. In 87 he succeeds. And
He
you file
succeeds.
your appeal.
I file my appeal. And my appeal ought to have been decided. In the meantime, some party has filed. Now what is happening? 12 years also.
We do not know who are the parties in the suit.
I know. Parties are not, yes. Because I have
So whosoever be the parties, but they are claiming under either of you. And
Well,
both of you are the party.
They have filed a cross suit. There's a third
It
party
is-
is claiming
it is
title,
a-
and my
they-
learned friend's client has
No,
filed a suit.
he has also filed a cross suit. I have also filed a cross suit. In that case, he is claiming possession. I am also claiming.
Very good.
So it is a cross suit filed by both of us.
Two cross suit and one suit.
So, Mara, this question of 258 cannot be decided here. It is for them to raise it there.
So 258.
So today what you are to
If
decide?
there is any objection with regard to 258,
That will have to be raised there.
But I will raise. Certainly I will raise 258. But question is, in garb of that suit, would you not decide my appeal here? Because it is the proper remedy I am taking. And I am availing a proper remedy. So appeal was the proper remedy for me. And suit is rather barred. My friend is suggesting me that you go challenge that suit and take a plea before the civil court that it is barred. Yes, of course I will take that. But question is only one. The limitation issue is not decided. मतलब section 87 qua parties issue was decided.
If you take a plea that it is barred, then under such circumstances the order under section 87 is in their favor, isn't it?
So, section 87 order is in their favor. I say that the suit under 87 was barred. That would not have been entertained by the authority under hearing under suit under section 87. So my only contention is that my arguments before the appellate authority would have been decided on merits. How can he take a reference of a suit pending, which according to me is otherwise also barred under section 258? How, for that purpose, he refers to that suit and says, I am not deciding your appeal, wait till the decision of the suit comes. So, here I am. One more judgment of this Honorable Court is Kali Mahato, page 22. Where the relevant portion. Para 8. Kali Mahato is page 22, coordinate bench.
Yes.
Lordship saw that.
Yes.
It reads like this. Both the parties claim title on the suit land. Both the parties claim title on the suit land on the basis of the sale deed by Fulmani Matain, wife of so. It is not in dispute that the sale deed in favor of applicant was prior in time to the opposite party. Therefore, by operation of section 48 of the TP Act, the right title and interest of respondent opposite party over the suit property will be subject to that of applicant. The learned appellate court completely misdirected itself to hold that revenue court has got no right to interfere in the title of the CMT Act is a suit that is filed within 3 months of the final publication of the revenue court has power to adjudicate in the matters of title after 1920 amendment by inserting section 87(1)(EE). Once the party
But at the same time, this 1986 judgment says that it is exercising power of a limited jurisdiction regarding only entry made in the record of
there
right.
is an amendment, can we have?
That's right, we are aware of that. E is a very old amendment. It
Yes.
is not after 1986.
Therefore, what I say is, it says that it says further, if the language of 87 is seen, kindly have. If instead of any judgment, let us go by.
You see, in METI it says that is why the legislature has chosen to provide a narrow limitation of 3 months from the date of the certificate of the final publication of the recorder for bringing such a suit. Section 87 provides special and additional
Right.
remedy pertaining to entries in revenue records as soon as they are finally published and
So,
certified.
what does it say? Maiti says it is an additional remedy.
Yes.
If you have availed that remedy, then can you retract? You have availed a remedy under section 87.
You see, you have availed a remedy under section 87.
87.
So what becomes final? The entry in record of rights become final.
Kindly see,
But the title does not become final.
kindly have section 87
EE.
EE. Right. It says, as to the question relating to the title in land or to any interest in land as between the parties to the suit. I'm not saying that.
That particular provision,
But
while passing this this judgment in Parithos Mehti, that jurisdiction stands limited. Limited only with regard to the entry in record of right.
But Parithos Maiti also says that if you have already availed the remedy under 87, then you cannot choose to file a suit later on. You cannot. If Parithos Maiti
You
and
cannot go for a title suit for declaration of
for
title and
declaration
recovery
of
of
title
possession.
later on. Yes, kindly have that
And
language again.
recovery of possession.
Yes, that yes. Recovery of possession is a different thing, but kindly have Parithos Maiti again. That language I read it fast.
Thus, if the actual resort has been made to a suit under section 87, then and for an identical list, section 258 would bar a further resort to civil
It
court
bars.
except on the ground of fraud or want of disclosure.
उसके आगे पढ़ा जाए
Para 21 of Paritosh Mahiti answers it. Why are we going
just para 16 हम पढ़ देते पहले.
क्यों time waste करें? Para 21 देखिए. And what it says is not to finally conclude.
Para 22.
Para 21.
ठीक तो. Yes.
No, no, I was.
वही तो है.
नहीं है वो आप जो कह रहे हो वो नहीं.
Yes.
To finally conclude,
The answer to the question posed at outset is rendered in the affirmative both on principle and precedent. It is held that civil suit for declaration of right of title and confirmation of possession and inter alia challenging entries in the revenue records would still be maintainable even after insertion of clause E in section 87 of the
Correct.
CNT Act. What it says is, Paritosh Mahiti, is this, that if you have gone for correction of record of rights under 87, then you cannot file the same suit for challenging the record of rights. That is barred.
but you see, record of right. Your title may not be declared on the basis of entering record of
I
right.
agree. I agree. What I say is what happened. Paritosh Mahiti says
You see, it is something like there is a title dispute, two people are having the sale deeds, right? And at the time of entry in record of right, both of them they come with their respective sale deeds.
but Manoj kindly
And let us
Right.
think of a situation, and the vendor is the same, and there are two sale deeds. So the entry in record of right will be based on the earlier sale deed.
Correct.
As simple as that. So these kind of disputes, while making entry in record of right, can be resolved by the revenue authorities under section 87. But when it comes to intricate question of right, title, interest, possession, etc., then under such circumstances, civil
But
court will
kindly
have
have
the
this-
jurisdictions.
again see Manoj section 87 what does it say?
Yes.
Malad, about those intricate questions, first proviso says, provided that revenue officer may, subject to such rules, may be, as may be made in this behalf under section 264, transfer any particular case or classes of cases to a competent civil court.
That's right.
It says so.
If
So,
he,
Malad,
if he does not exercise that power,
Yes.
does it bar the
So,
remedy of the person?
Yes. So, Malad, my limited Malad, argument over here is that Malad, section 16 read with section 20, paragraph 16 read with paragraph 21 of the Malad, Paritosh Mahiti, it is very clear if party has already approved with respect to Malad, correction of entry only. What is happening here? Section 89 between the parties in 86. Then 1996 Malad, is the final publication coming. Malad, 1986, Malad, the application under section 89. 1996 final publication is taking
That
place.
date we have no.
Yes.
We have
Now
the
what
dates.
will happen? Malad, he loses 89, sits over. He waits for 10 years after final publication, sits over, and limitation has been entertained against the spirit of law, although it is prescribed for 90 days, and then in the name of a suit which is pending, the same party may be, I am the defendant in that case, I am not a plaintiff, or he is also not a plaintiff. So somebody has filed, and he and we have filed a counterclaim. So in the name of that, there is no details of that also. Para 5 reads how it says, the Lordship asked me what exactly has been said in the appeal. It says, it reads, this appeal is filed under section 87(2) of the CNT Act against so and so, so and so.
You
so and
go
so.
to para 5 straight away.
Now, if para 3 देख पर the present appeal was filed dependent on the ground that notice was not validly served on him, and the learned court below also failed to consider CNT case number 18.
There is one more question here. There was one more petition filed under section 89. That revision was also dismissed perhaps.
That is at the interim stage.
At interim stage.
89 is at the interim stage.
That is
Interim. It is not final.
but below that aspect attains finality and limitation will always stay at them because below it happened in 1990.
We will decide.
Yes. So एक पैराग्राफ खाली हम दिखाते हैं बस जो डिसाइड नहीं हुआ मतलब पारा 3 89 वाला मतलब 5 पारा 5 of the appellate court. In course of argument, learned counsel for the respondent filed list of documents which contained the order dated 6/3/86 passed in CNT case number 1863 of 86 by the estate settlement officer under section 89 of the CNT Act with respect to above mentioned land, and it discloses that a proceeding between Janak Singh and Radha Mohan Lal, it was ordered that a portion land to be recorded in the name of Janak Kumar Singh. Other document, namely plaint and written statement filed by defendant number 1 Rajendra Singh Chahal. I am not Rajendra Singh Chahal, not concerned with that. Chahal, in title suit number 194/15, goes to show that the property involved in the present proceeding is the scheduled property of the title suit number 194/2015, and the respondent of the present proceeding is represented by defendant Rajendra Singh Chahal in the suit where he filed the written statement in para 31 so and so of the written statement. He has especially stated he had purchased the suit from respondent. Similarly, appellant and other claimants of the suit property are parties in the title suit 194. Then he simply says yes, decided.
So parties are either themselves or they are claiming through the parties.
Well, through parties there is a suit filed by someone
There
else
is a sale deed.
and someone else, and through sale deed. We are all opposing
Party.
that. We are party. We are having our own claim. So would that suit preclude the appellate authority to decide my appeal, in which I am raising three questions. Number one, जो आपके issue number 3 है. Issue number 3 precisely यही है. Issue number 1 है limitation का. So limitation पे हमारा यही कहना है कि it is a suit, and section 29(2) also of the Limitation Act very much provides that if it is a specific time prescribed, otherwise what will happen? 30 days, 90 days, it will stand otherwise. And the summary remedy or summary proceeding, as Maiti also says, will get thoroughly frustrated. 12 years, 15 years, anyone will go anytime. So that.
Can I take 2 minutes? It's not more than 2 minutes. My team I don't think the question whether the subsequent suit is barred in way of 258 is a question that should be answered by your lordships. Because this issue whether the subsequent suit is barred is not a question before your lordships. It's not a question. Therefore, all these mighty whether it applies is according to me is not necessary. Number 2. Now the fact is a suit is there. I have filed, you have filed, all are claiming title. Three of us are claiming title. The suit, my claim is barred, is held to be barred under 258. For a moment, let me assume. And his claim is allowed. Then the appellate court has said the impugned order will be decided. The appellate order's lying word is, the finding is,
Shall be guided.
the propriety of the impugned order shall be guided by the decision. So, in case my suit or my claim is found to be barred by law, gone. If his claim is found to be correct, his name will be. Therefore, in effect, my lords, even if it is not there, ultimately that is going to happen.
So, what then?
So here, my learned friend is wrong in saying that if I had two options with me, either come to 87, whether related or not, that's a different, or go to suit. I have come under 87. So what is barred is a subsequent suit, which is not a say 87 I rightly filed, maybe beyond period of limitation. That's a different question. So you can't question that even as per my thing. Ultimately, whatever is the point, this will prevail. The ultimate observation. So why should your lordships touch this? When in law, the law is settled, the judgment in the title suit, right, wrong, whatever will happen, or appeal, will prevail between the parties. There is no question that the record of rights.
Ultimately, whatever, according to you, whatever be the title decided amongst the parties,
it will be
that will prevail, irrespective of entry in record of rights.
Correct, Subhedra. That is what
But
will happen.
his concern is that entry in record of right,
Yes.
which stood modified or whatever by virtue of section
59.
87 order,
Madam,
that will have a much evidentiary value.
Your Lordship is saying, Your Lordship will hold this. My learned friend has got an order.
What I'm saying.
It will-
Otherwise,
that is where the shoe is
my
pinching.
friend agree.
I will support it.
I'll concede right now. If my friend is arguing like this,
This is
let
where
him
the shoe is
say,
pinching.
let him say both orders will go.
No.
We will wait.
We have
Why
just
does he want to
kindly-
entry in his own favor?
Kindly have Jitendra Singh, I have just passed on the judgment and I will pass on a division bench judgment passed last week where he was, same thing was happening. The division bench says, ultimately this entry or mutation, you
So-
cannot create a
so
right title
what I
interest.
say is-
Your Lordship may hold it, that this has no, just allow me, this has no value. This title suit will be decided independent of this, without being prejudiced by this.
No, let that order also go. Both the orders should go. I was in appeal, my
Rent on
appeal has
them.
not been decided.
Rent on
So
them.
let those both the yes, I'm paying. Same
See,
thing you accept with
ultimately,
me.
you see, if it is held that it is barred by limitation at the threshold,
Then-
everything goes.
Yes,
Everything goes.
right? Everything
goes and my title.
And-
That also
and-
observation may be.
And
made.
if it, that's
No,
also
if it
observation.
goes-
That
That's a
observation
legal
may
issue
have-
which I have to
I am
decide.
grateful,
That
but
has a.
if it goes, then Your Lordship will have to protect my right to, because I can't be non-suited from everywhere.
I will leave the parties for
Correct,
their remedies.
Yes,
The point is that if that is barred by limitation,
then I have a right to go and file institute a suit provided it is within limitation.
No, you can't.
नहीं, अब दोनों थोड़ी हो सकता है.
No,
अब
now
आप
you
भी-
cannot. अब तो आपका सूट चल रहा है for
हम
you.
तो क्या?
आप उसमें लड़िए.
हाँ तो लड़ी नहीं.
What is that suit?
he will come with section 14.
Yes, we'll all take.
वो
वो है ना?
कुछ
होगा कुछ में
उस
सुट
समय
में
देखा
थोड़ा
है।
हम लोग लड़ लेते हैं. अब I think we have all exhausted our fees paid to us.
yeah.
चलिए आर्गुमेंट्स कंक्लूडेड. अभी इतना कौन लिखाएगा? कुछ इसको लिखा लेंगे. इसको लिखा लेंगे. चाहे थोड़ा बहुत अभी भी लिखें. Let me see if I can do it. For judgment on 26/8. चलिए एक पार्ट चल रहा है कल से. Yes.
From supplementary list permission item 4 WPC 5375 of 2012.
Yes. You just respond to the point one by one, right? सारे जितने इन्होंने points raise किए हैं, point wise respond. तो एक note sheet तो था ऐसे. Supers को देखिए इसके अंदर भी होगा. आपने पहले भी शायद दिया हुआ है.
हाँ वो पहले भी किया था लेकिन वो नहीं मिल रहा था फिर कल भी
ये हाँ. ये दिखाइए तुमको यही वाला था.
हाँ जी
ठीक है निकालिए किसी.
से जो चल रहा था 2012 से, तो 16 में तो काउंटर एफिडेविट फाइल किए थे जो कि डिटेल में था, और जैसा रिट बनाया गया था उसी का रिप्लाई किया। ये फिर 2023 में जो हम इसको बनाए रिटन आर्गुमेंट को, ये फाइल ऑन एफिडेविट तो नहीं किए लेकिन फाइल दिए हैं। इसको काइंडली देखा जाएगा जो कि इसमें 226 और 227 दोनों रिट जुरिसडिक्शन को इन्वोक किया गया है। तो मैंने कहा कि 227 में नहीं चलेगा क्योंकि क्वासी जुडिशियल ऑर्डर है, और ये जो है जो सबऑर्डिनेट जज का जो ऑर्डर को रेफरेंस कर रहे हैं वो उसको चैलेंज नहीं किया जा रहा है यहाँ पे, क्योंकि वो है ही नहीं फोरम।
This is too technical a point. 226 लगा हुआ है, 227 लगा हुआ है, नहीं लगा हुआ है,
ठीक है, क्योंकि
नहीं मतलब आप जो ये पॉइंट रेस कर रहे हैं इसका जवाब हम आपको साथ साथ देते रहे हैं. It is irrelevant.
ठीक,
So we can omit this. Can we?
ठीक ठीक।
Next.
Next है ever named petitioner cannot challenge the order dated 7/1/1987 passed by the settlement officer Dunka in 40 case number NSA 2 31/1986 series because this order was already challenged before the learned commissioner. वो एक बार ऑलरेडी जो टेस्टिफाई वहाँ नीचे भी कोर्ट में हो चुका है, तो उसको भी
This is technically not correct क्योंकि जब भी यहाँ पे हम लोग ऑर्डर्स चैलेंज करते हैं, जैसे HRC केसेस में भी ऑर्डर्स चैलेंज होते हैं, तो HRC
हाँ,
केस का ऑर्डर चैलेंज होता है, एपिलेट ऑर्डर चैलेंज होता है, रिविजनल ऑर्डर चैलेंज होता
सही
है.
बात,
तो इसीलिए इस पॉइंट का बहुत रेलेवेंस है.
ठीक है, ठीक है,
देखिए आपको इसलिए बता दे रहे हैं क्योंकि मतलब हम सीधे मुद्दे पर आए तो ज़्यादा अच्छा है. ठीक है, इसको भी क्रॉस कर दें.
ठीक।
नेक्स्ट में
Under Article 226 of the Constitution of India, this court has no jurisdiction to that. इसमें ये वाला था with respect to the land in question because the section 10 of the Santhal Permanency Law does not permit to do. ये कह रहे थे prayer C में कि मेरा नाम को insert कर दीजिए उसमें.
that will be a consequential link.
नहीं, आप मैंने कोर्ट को कह रहे थे,
See,
कोर्ट को ही कह रहे थे.
उनका कहना ये था कि 50% मेरा होना चाहिए. That was their case. कि मतलब पूरा आपका हटाने का बात नहीं है. इनका कहना ये है कि आपका और इनका 50% 50-50 होना चाहिए.
सी में जो जिस तरह से किए हैं
उनका नहीं हो सकता पूरा. Your name will be only to the extent of 50%, correct?
Yes.
Nothing more than 50%. ऐसा नहीं है कि आपको पूरा हटा दिया जाएगा. It's not like that. Nor that is his case. This prayer, if it is there, it is wrongly worded.
ये सी में जो है
वो नहीं हो
पढ़ देते एक बार. Upon quashing the impugned order dated 7/1987 passed by the settlement officer Dunka in 40 case number 31 of 2006 as well
31 of 86.
हाँ वो टाइपिंग इधर है. Order dated 25/5/2012 passed by the learned commissioner Santhalpana division Dunka in revisional miscellaneous case number 27 by 1987-88. Be further pleased to direct the concerned respondent authorities to enter the name of the petitioners with respect to the land in question.
नहीं ये नहीं हो सकता. I hope he will concede to that agreement.
Yes.
You are claiming only 50%. We'll take care of it. आगे बढ़ते.
उसके बाद जो इसमें जो 40 केस का जो कागज लगा हुआ है उसी में जो देखा जाएगा कि उसमें जो जेनोलॉजी दिए हैं उसमें 3 पार्टी कंसर्न था. एक मिनट. 2 different genealogy table was prepared and submitted by the above named petitioner in proceeding of 40 case number LAR case, 40 case and LAR case.
देखिए इनका उससे कोई लेना देना नहीं है. उन्होंने क्या जिनोलॉजी दिया, किसने क्या दिया, इनका बस एक ही कहना है कि जमाबंदी नंबर 20 है पर.
हाँ जो जी.
हाँ उस जमाबंदी से ही related there was a land acquisition proceeding where there was a dispute regarding apportionment.
हाँ.
And that was the only dispute which was involved, and in that you and they both were parties, and in that proceeding it was decided that it is 50-50. Correct?
हाँ ठीक ये.
This is his case,
Yes.
right? And this particular proceeding is also relating to the same Jamabandi. At the time of initial order, that land acquisition case was not finalized. But at the appellate stage, this was finalized. But the appellate court has just brushed it aside by saying that the collector is not giving effect to it.
ये जो है जो कमिश्नर के कोर्ट में या 40 केस के प्रोसीडिंग को चूंकि कंटिन्यूएशन में केस हो रहा था, तो ये तो बीच में तो था ही. लैंड एक्विजिशन का केस जो है वो तो उसके बीच में आया ही है.
आया है, ठीक है.
और उसमें भी जो देखा जाएगा कि वो फिर अपील भी हुआ है जिसको कि फिर नॉन प्रोसिक्यूशन में ही खत्म हो गया है. वो भी स्टेटमेंट
ठीक है, that is also there.
हाँ।
I've seen that. You
तो-
filed an appeal against the land
अच्छा,
acquisition
ये जो
proceeding
है
also.
जो मतलब कि लीगल हेयर का बात है, ये तो डिस्प्यूटेड क्वेश्चन ऑफ फैक्ट में आता है। अदरवाइज या तो सीओ से करा के दे या तो फिर जो कोर्ट से
नहीं
करवा।
नहीं, ऐसा कोर्ट से तो डिक्लेरेशन हो गया ना।
कोर्ट से डिक्लेरेशन इसके ऊपर कहाँ हुआ है? ये दोनों में अलग अलग है इनका जेनोलॉजी, इसलिए मैंने पॉइंट आउट किया कि फौती केस में अलग है और एलएआर केस में भी अलग है। दोनों जगह जो है जेनोलॉजी जो है, ये जो
एडजुडिकेशन हो के 50-50 हो गया कि नहीं?
नहीं,
एडजुडिकेशन एलआर केस में
एक मिनट जो मेरा बात सुनिए कि ये जो है जो कोर्ट से जो कह रहे हैं इस बात को, लेकिन जो प्रोसीडिंग स्टार्ट हो रहा है, क्या वो प्रोसीडिंग में ये कह सकते हैं कि फर्स्ट ऑफ ऑल आप ऐसा कर दीजिए? तो ये किसी भी कोर्ट में नीचे में जेनोलॉजी को करेक्ट नहीं किए हैं। हाँ, ये क्लेम तो कर सकते हैं, मैं भी क्लेम कर रहा हूँ, लेकिन अब जेनोलॉजी का करेक्शन जो है ये खुद जो है दो जगह दो तरह का जेनोलॉजी दिए हैं, फौती केस में और एलएआर केस में। हम देखे हुए डॉक्यूमेंट, उसके बाद ही इसको बनाए थे। तो ये पॉइंट हम एक लिए, टू डिफरेंट जेनोलॉजी टेबल वाज प्रिपेयर्ड and submitted by the above named petitioner in the proceeding of Fauti case and LAR case.
demonstrate this.
हाँ.
And if two different, you have to demonstrate both.
हाँ.
You have to demonstrate that whatever genealogy they had given and how the court has ultimately accepted the genealogy. Ultimately, the finding of the court will prevail.
तो यही ना बात मैं यही कह रहा हूँ कि फॉर्थ प्रोसीडिंग जो है ये जेनोलॉजी से रिलेटेड नहीं है, लेकिन ये जेनोलॉजी ये जब आएंगे तो जो इनके मन में वो तो कोर्ट को बोलेंगे ही। ये तो जो प्रॉपर्टी है चूंकि इशूलेस हो गया और इशूलेस होने के बाद वो बंद हो गया, तो एज पर द एसपीटी एक्ट वहाँ पे फॉर्थ प्रोसीडिंग स्टार्ट हुआ और वहाँ पे सभी लोग गए अपने जो भी इनसे जुड़े हुए थे कि नहीं मेरा
ये कोई फ्रेश सेटलमेंट नहीं हुआ। फोर्थ प्रोसीडिंग होने के बाद एक फ्रेश सेटलमेंट होने की बात दूसरी होती है, लेकिन फोर्थ प्रोसीडिंग होने के बाद द कोर्ट फाउंड दैट यस समबडी इज एंटाइटल्ड टू दिस प्रॉपर्टी बाय वे ऑफ सक्सेशन। तो फोर्थ प्रोसीडिंग अल्टीमेटली कल्मिनेटेड इन रिकॉर्डिंग ऑफ द प्रॉपर्टी इन द नेम ऑफ वन और द अदर पर्सन हु वाज फाउंड टू बी द सक्सेसर ऑफ द ओरिजिनल टेनेंट।
हाँ, सही ये बात।
तो फोर्थ अदरवाइज तो किसी और को एलोकेट हो जाता, थर्ड पार्टी को। वैसा तो नहीं हुआ।
नहीं तो फिर वो वाला 16 आना रैयत में होता फिर।
हाँ, वो दूसरा होता।
16 आना रैयत।
दैट इज अ सेपरेट प्रोसीजर।
तो वो यहाँ पे नहीं, यहाँ पे फोर्थ प्रोसीडिंग था। और यहाँ पे जो जेनोलॉजी की बात कर रहे हैं वो भी देखा जाए। एनेक्सर इसमें जो है 2 है और पेज 44 से देखा जाएगा। 18/3/86 का ऑर्डर जो है
किसका पेज कौन?
रिट का, इन्हीं के मेन रिट में ही जो है जो एनेक्सर लगा हुआ है।
क्या है?
ये देखिए जेनोलॉजी है जो पेज 47 में सिराज पिता गुलाब अहमद और फिर नीचे में सोहरा बीवी। इसका टाइप कॉपी तो हमको नहीं दिए हैं, लेकिन यहाँ पे देखिए वो जो भिखारी और नरीमन ऊपर में ही है 47 पेज पे। ये एक जेनोलॉजी है यहाँ पे।
पेज 54 में भी एक जेनोलॉजी है।
हाँ, एक वहाँ पे भी है। इसमें टोटल जो मतलब कि लोग आए फोर्थ प्रोसीडिंग में, उसमें से ये 2 जो है माने रह गए। अदरवाइज इसमें 3 लोग आए थे, 4 लोग क्लेम किए थे इसमें फोर्थ प्रोसीडिंग में। 4 पार्टी क्लेम किए थे।
क्लेम करे से क्या मतलब? बाकी तो कोई पार्टी यहाँ पे नहीं है।
डॉक्यूमेंट उनसे भी रिलेटेड स्टेटमेंट दिया हुआ है।
ठीक है, it does not make any difference.
हाँ।
There is already an adjudication with respect to interstate right between you and the petitioner. चलिए और नेक्स्ट
फिर 49 में भी देखा जाए नीचे में द्वितीय पक्ष असगर खान एवं याकूब खान की ओर से विद्वान अधिवक्ता का
इन्होंने अलग अलग अपना जिनोलॉजी दिया। क्या
हाँ।
जिनोलॉजी को डिसबिलीव किया गया है?
हाँ,
कहाँ पे फाइंडिंग?
इसको पढ़ देते हैं। ये 3/4/86 का जो ऑर्डर है अभी द्वितीय पक्ष असगर खान एवं याकूब खान वाला, उसमें देखा जाएगा जमील खान पिता रसूल खान, नाम अपना जमीन जोत आबाद याकूब तथा इब्राहिम खान करते हैं, ये ही खजाना भी देते हैं एवं खुदा बख्श पिता शेख कयूम वाला का कहना है कि वादनी जो आवाज करते हैं इब्राहिम के लड़के असगर खान है। विद्वान अकबर का कहना है कि एक दूसरे अधिवक्ता का कहना है कि एक दूसरे दावेदार इद्रिस है। इद्रिस खान हक नहीं है। इनका यह भी कहना है कि इद्रिस अलीदाद खान नहीं है। दूसरी शादी से लगभग फिर उसके बाद जो पेज 51 में आ जाएगा, इसमें 26/5/1986 का ही एक ऑर्डर है। ग्राम श्री अमरापाड़ा थाना नंबर 29 के जमाबंदी नंबर 20 की जमीन नावल पाई गई। इसके खतियानी रैयत कैंजर सेटलमेंट में जहरजान बीबी थी। गत खानापुरी के समय एक शहीदान बीबी का नाम अद रैयत के रूप में दर्ज है। इस नामजारी का कुल रकबा 11.72 एकड़ है। इसमें से केवल एक खेसरा संख्या 500 इतना पर मैनेजर हेम्ब्रम का दर्ज है, कब्जा दर्ज है। इस खेसरा का रकबा मात्र 0.43 डिसमिल है, परंतु मैनेजर हेम्ब्रम कभी उपस्थित नहीं हुआ है। इसका देखिए पेज नेक्स्ट पेज में ही अफजल खान का जेनोलॉजी है। इसमें अफजल खान है, उसका बाद नीचे जमील खान, अमीर खान, जमील खान से रसूल खान, ये सारा का सारा जो है जहरजान बीबी।
Parties in the suit and parties in this proceeding are the same.
हाँ,
ठीक, आगे बताइए।
आगे वाला पॉइंट
Next point.
फिर तो वो तो खैर है ही, डिस्प्यूटेड क्वेश्चन ऑफ फैक्ट को नहीं डिसाइड करते। ये भी कह रहे थे कि नहीं हम उस पे नहीं जा रहे हैं। Above named petitioner has not filed title suit for declaring their right, title, interest, possession over the disputed land in spite of the year 2012. उसमें जो है लास्ट में जिस चीज को चैलेंज किया गया है, जिस इम्प्यून ऑर्डर को, उसमें डायरेक्ट लिखा हुआ है कि आप जो है अगर नहीं इससे बन पा रहा है तो आप सिविल कोर्ट जाएंगे टाइटल के लिए। ऑन द नेक्स्ट मेरा कहना, ऑन द ओकेजन ऑफ नो लीगल हियर वेयर सर्वाइव of record tenant Jharkhand BB. Fourth proceeding under SPT Act was initiated by the settlement officer, and in that proceeding, 4 parties were participated in the 40 case. एक जो है 8वां में सेक्शन 25 ऑफ द SPT एक्ट, ये जो देखा जाएगा। रिकॉर्ड्स टू बी फाइनल, अगर देखने का मैंने जरूरत पड़ा तो रिकॉर्ड्स टू बी फाइनल आफ्टर 6 मंथ पब्लिकेशन। पैरा 12 ऑफ द रिट पिटीशन का रिप्लाई है ये। सेक्शन 25 देखना है SPT एक्ट।
नहीं सर।
द संथालपना सेटलमेंट रेगुलेशन 1872 सेक्शन 25 record to be final after 6 month publication after a period of 6 months from the date of publication
किसके
of
नाम से रिकॉर्ड
Judicial.
कौन सा
अभी
रिकॉर्ड
तो-
फाइनल बोल रहे हैं? ये रिकॉर्ड बिकम फाइनल अगेंस्ट इन कनेक्शन विद होम।
ये जो जिसकी कह रहे हैं कि ये इनका नाम भी आना चाहिए, इनका तो हत्यान भी है, सारे डिफेंडेंट प्राइवेट
ये
रिस्पोंडेंट के
सेक्शन
नाम पे।
25 का जो आप बोल रहे हैं, तो
जी।
कौन सा रिकॉर्ड अकॉर्डिंग टू यू हैज बिकम फाइनल?
हाँ,
व्हिच
वो
रिकॉर्ड
वो,
हैज
वो
बिकम
जो
फाइनल?
गैंजर सेटलमेंट के समय में जो जान बीबी का नाम चल रहा
तो
था,
इसमें कहाँ कोई डिस्प्यूट?
उसके बाद फिर जो है नहीं, उसके बाद इनका भी आ गया, जो एनेक्सर भी है, जो मेरे काउंटर एफिडेविट में कल हम हुजूर को पढ़ के बताए थे कि उसमें खतियान भी लिखा हुआ है, उसमें खतियान 1932 का खतियान जो है उसमें सभी प्राइवेट रिस्पोंडेंट का नाम आया हुआ है, उनके ही फैमिली से रिलेटेड है। अगर उसी खतियान में अगर इनका भी नाम होता तब तो कोई बात ही नहीं था, तो वो सरकार भी देती। उसके बाद भी लैंड एक्वायर हुआ है तो सिर्फ इन्हीं लोग को पैसा मिल रहा है, उनको नहीं मिल रहा है। ये तो क्लेम कर रहे हैं लगातार कि हम उनके तरफ से आते हैं और मेरा है, लेकिन हर बार ये जो है वहाँ पे टेस्ट हो रहा है और नहीं इनपुट मिल रहा है। ये जो उस रिकॉर्ड के लिए कर रहे थे कि 1932 का खतियान में भी तो अभी जो है तो उसमें तो चेंजेस नहीं आएगा, क्योंकि वो तो सारा कुछ कर दिया गया है। और अगर गैंजर सेटलमेंट का देखा जाएगा तो उसको भी हम लोग चेंज नहीं कर सकते हैं। तो उसी के रिस्पेक्ट में हम कह रहे हैं कि सेक्शन 25 यहाँ हिट करता है। वो कहता है कि अगर कुछ है भी उसमें तो उसको जो है विद इन 6 मंथ ही क्लियर कर लेना था। After a period of 6 months from the date of publication of the record of right of any village, such record shall be conclusive proof of rights and custom therein recorded other than the rights mentioned in section 25A, except so far as concerned entries in such record regarding which objection by parties interested may still be pending in the original or appellate court or may still be open to appeal. जैसे अभी हम लोग के यहाँ जो सर्वे का जो चल रहा है, तो ये गैंजर में और
आप हमको बताइए कौन से दिन में कौन सा किसका राइट?
ये रिकॉर्ड ऑफ राइट के लिए हम कर रहे हैं कि जिसमें
कौन
कि
सा रिकॉर्ड
प्राइवेट
ऑफ राइट?
जो 32 का खतियान है और उसके पहले का जो जहजान बीबी का था गैंजर सेटलमेंट का।
आप एक बात बताइए, इतना जो यहाँ कहानी हमको सुना रहे हैं, ये कोई भी चीज वहाँ पर प्लेस हुआ है किसी भी अथॉरिटी के पास कि रिकॉर्ड ऑफ
नहीं,
राइट में ये
हम
एंट्री है?
हम तो हर चीज को वहाँ पे प्लेस कर रहे हैं। अब जो कोर्ट कंसर्न है,
कहाँ पे प्लेस कर रहे हैं? क्योंकि जो
अब
इम्प्यूट
देखिए,
ऑर्डर है उसमें
हम
तो ये सब
डिफेंडेंट
just a
का हो गया
moment.
है,
जो
रेट
भी
तो हम नहीं
है,
बनाए हैं।
that's right.
हाँ।
But the impugned order is not reflecting any of the things that you are referring. आपने पूरा सूट का डिपोजिशन जो हम पढ़ने बोलेंगे तो एक भी पढ़ नहीं पाइएगा, I can guarantee you, right? सब लगा दिए हैं।
नहीं, हम कहाँ लगाए हैं?
ये कौन लगाया है? सप्लीमेंट्री एफिडेविट?
हाँ, वो उसके ऊपर भी आ रहे हैं।
हाँ नहीं, यही तो हम बोलना चाह रहे हैं आपसे। ये जब सप्लीमेंट्री एफिडेविट लगाए हैं, इसका
उसी में
डिपोजिशन आपको पढ़ने बोलेंगे तब पढ़ेंगे।
मैडम हम तो पढ़ेंगे, आप टाइम देंगे हम पढ़ेंगे।
ये क्या
क्योंकि इस
चीज
तरह का भी
है?
नहीं
ये
एक्सपीरियंस
सूट
है कि
में
नहीं
क्या-
पढ़ सकते हैं।
सूट में
अब
एक-
उसको लगाने का
अच्छा
पर्पस जो
ठीक
देखा
है,
जाएगा।
आपका बात हम सुन लिए और बताइए कौन सा
हाँ,
पॉइंट?
नेक्स्ट पेज में उसका सप्लीमेंट्री एफिडेविट में देखा जाएगा।
ठीक है,
जो पहला
और
पन्ना है
बताइए
उसका पहला
बस
लाइन में।
आपको 2 घंटा से कल अभी मतलब कल सुने थे आधा पौन घंटा, अभी भी सुन रहे हैं, आपका एक एक पॉइंट हम देख रहे हैं, आप हमको बताइए।
ठीक। क्लेम ऑफ द पिटिशनर एट 2 टाइम, ये ठीक है। पैरा 10 ऑफ द रिट पिटिशन, हम रिपीट नहीं करते हैं पॉइंट, मैडम भी देख रही हैं।
ठीक
Para 10 of the writ petition, petitioner did not mention under which section of land acquisition act the LAR case was referred to the subordinate judge. ये जो है हम इसलिए लिख रहे हैं 2 जगह से, और इसी के रिस्पेक्ट में हम सप्लीमेंट्री भी उसको कह के फाइल किए थे। ये इसमें देखा जाएगा। And no entire order sheet was filed along with the reference letter, and this is not certified copy of award. वो सर्टिफाइड कॉपी भी नहीं जो हुजूर के सामने रखा गया है। और दिस इज नॉट द इम्प्यूग्ड ऑर्डर ऑफ द रिट पिटिशन, उसके ऊपर कुछ एक्शन भी नहीं लेने के लिए कह रहे हैं। प्रेयर में ही नहीं बोल रहे हैं कि हाँ उसके ऊपर कुछ एक्शन लेना है। हाँ, उसका रेफरेंस तो लेंगे ही क्योंकि एविडेंस में आएगा, वो ट्रीट हो रहा है, लेकिन वो सर्टिफाइड कॉपी है तो इसीलिए किस लेवल का एविडेंस है, फर्स्ट प्राइमरी है, सेकेंडरी है, टर्टरी है, वो देखने का चीज है। ऑब्जेक्शन वाज नेक्स्ट है, ऑब्जेक्शन वाज रेज्ड इन एनफोर्समेंट ऑफ द शेयर अमाउंट एंड thereafter reference was made to subordinate judge, but on which here objection was raised not mentioned by the petitioner, कभी भी नहीं बताया गया। after the acquisition of land, a straightly railway track in between Mandar Hill to Rampur Hat in the year 2004. Again, acquiring land of the competent authority and compensation amount disbursed in favor of the private respondent number 11, जो कि जो काउंटर एफिडेविट में भी हम लिखे हुए थे उसी को यहाँ पे दोबारा लिखे हैं. Name of all the private respondents 6 to 14 was inserted in the original खतियान, a state government record of right. ये सेक्शन 25 से जो अभी जो हम पढ़ रहे थे उससे रिलेटेड है. As per my information, objection was received under section 18 of the, वहाँ 19 लिखा हुआ है मुझे, 18 और 19 दिखाएंगे हम of LA Act. और इसमें जो देखा जाए लैंड एक्विजिशन एक्ट जो है, क्योंकि जज साहब के जो ऑर्डर को दिखा रहे हैं उसमें 30 लिखा हुआ है, सेक्शन 30 ऑफ LA Act.
ठीक है, ऑर्डर सुनिए.
यहाँ देखिएगा जो लैंड एक्विजिशन एक्ट
Just
का
a moment. He is referring to many materials. He is also referring to certain other orders under the Land Acquisition Act, right? And then you have this order adjudication passed by the competent court. The appellate, the Court of Commissioner has simply discarded it for no reason, right? And there are so many things he is talking about. He has brought many things which certainly has not been brought to the notice of the court concerned. So this order certainly cannot be sustained. But whatever you have to say, both of you, let him examine whatever he has to examine. Because he is talking about some other orders also passed in the Land Acquisition Act, where the compensation has been exclusively paid to respondent number 11. Although that order has not been brought on record, we do not know what ultimately happened.
But that is prior to this judgment passed in this court, in this case.
No, it might be prior to the judgment passed in this case. They also have not brought it to the notice of the court.
Yes.
Nor you have brought it because it was for them because some order was passed in their favor. We do not know whether that particular proceeding has also attained finality, whether you have challenged it or you have not challenged it. We do not know anything about it. So these materials which he wants to bring it on record, we will remand the matter to the appellate authority. We cannot give a clear declaration that on the basis of this judgment, the property should be equally divided. But we will say that it is binding. We will certainly say it is binding because it has become final and the manner in which he has dealt with that is certainly not in accordance with it. That much we can say.
There are just certain judgments that I was aware on financial governance.
Yes. This is on what?
This is on the point that my judgment passed pursuant to a reference made on section 18 or 13 is particular made operates res judicata.
Yes, yes.
First
That
judgment
will
matters
operate.
here.
There is no doubt on that.
Yes.
That operates at
So that is why I am saying that an order of remand will also not do because ultimately if I have a judgment in my favor then the authority loses its jurisdiction. That issue cannot be decided fresh. There is a recent judgment as well by the Honorable Supreme Court that says that quasi-judicial authorities are also bound by the principle of res judicata. But if your Lordship may kindly see the first judgment, the 1952 to SCC 219.
Para number.
So you may invite the attention of this court to para 15. These two decisions, in our opinion, are conclusive on the point of res judicata raised in the present case, and in these circumstances, it has to be held that the question of title to the 4-anna share was necessarily and substantially involved in the land acquisition proceedings and was finally decided by a court having jurisdiction to try it, and that decision thus operates as res judicata and stops the cents and mortgagees from re-agitating that matter in the suit. We are now concerned with the question whether the privy council was right. The discussion starts from para 13, para 15 is the conclusion. So, why I am saying that the order of remand would not help because the Honorable Supreme Court says that if a decision has been passed under section 18 and 13, that will stop any further litigation with respect to the same issue. The next judgment matters 2025. This is on general principle, that principle of res judicata.
One judgment should be sufficient.
Yes, yes. In whatever meeting.
This is arising out of land acquisition proceeding.
No, this is on a general principle matters that
This section, this 1952.
Yes, this is arising out of that. Earlier also, Manas, I had relied upon the judgment by full bench of Honorable Patna High Court that has held that judgment passed in 18 and 30
Yes,
as a
when
force
is
of
that judgment? I think I was
1997 1 PLJR 17
1997.
1 PL. I have a copy of that.
Please.
Para 40 is the judgment. This is a single bench judgment Manas, on the same issue.
Have you given this judgment to us?
Yes, it's earlier also. It is recorded in the order also.
Yes, I've got that. This is 1997.
1 PLJR 155
1 PLJR
150.
155 full bench.
Yes.
Para number?
Para 40.
Para 40. What else?
Another judgment I have passed on this. The Lordship may kindly compare to paragraph number 7.
1973 SCC online Patna. 120. So para 7.
Yes. I'm allowed to place. Last part of paragraph 7.
Yes.
Fourth line from the bottom.
Yes,
It is only the question of the right and title of the respective claimants to the apportionment of the compensation money which is referred for determination by civil court under section 30 of the Act. And those parties are certainly bound by the adjudication of the court. And the same question cannot be tried and determined by any other court in a subsequent suit, as the right to apportionment necessarily involves the determination of the title of the claimant or the objector in the properties which may be subject matter of the acquisition, because it is only on the determination of these condition precedents that the court determines the question as to person entitled to the compensation. So once the court has decided the question of apportionment, the court also decides the question of right title.
Right.
And so far as section 25 that he was relying upon, I will not rely
No,
upon.
that is all.
But section 25 is not absolute, is all and subjective. It is subject to, ultimately subject to the rights of the
And
parties.
ultimately it was adjudicated by a competent court,
Yes, yes,
whatever it is, relating to the same Jamabandi.
yes, ma'am. Same Jamabandi.
What do you have to say to these judgments?
ये तो जो जजमेंट दे रहे हैं वो सेकंड अपील से रिलेटेड है और 9600 और उसके बाद का जो एक्ट में है प्रोविजन जो सीपीसी से दिया गया है उसमें रेस जुडिकाटा जो कि प्ले करता है, लेकिन हम लोग यहाँ पे रिट जुरिस्डिक्शन में रेस जुडिकाटा को प्ले करा रहे हैं। तो यहाँ पे इनको भी एक जजमेंट रिलेटेड टू रिट जुरिस्डिक्शन से होना चाहिए कि ये रिट में दिखाए कि भाई कैसे हम रेफरेंस लेंगे एक लैंड एक्विजिशन ऑफिसर का ऑर्डर जो फोटो कॉपी है और उससे फिर जो रेस जुडिकाटा को हिट करेंगे। और यहाँ जो एक चीज कहना था जो कि नहीं देखा पाए, ये जो लैंड एक्विजिशन का सेक्शन 18 है वो देखा जाए एक बार कहीं।
So far as submissions are concerned, there is no pleading to that effect. If your lordship kindly see his
What is
complaint.
लॉ हम सप्लीमेंट्री फाइल के ये भी नहीं कर रहे
He's only making factual submissions. But if your lordship kindly see
सप्लीमेंट्री
his
फाइल क्या हुआ
complaint.
है रेफरेंस देखा जाएगा।
Section 18 का क्या है?
Reference to court, section 18. Any person interested who has not accepted the award may, by written application to the collector, require that the matter be referred to the collector for determination of the court, whether his objection be to the measurement of land, the amount of compensation, the person to whom it is payable, or the apportionment of the compensation among the person interested. ये 18 है वो, और जो जजमेंट है उसमें रेफरेंस जो है जज साहब दे रहे हैं 18 का एप्लीकेशन आया है 30 का कह रहे हैं वो भी है एनेक्सर में देख लीजिएगा। पेज 32
किसका पेश?
ऑर्डर वही सब जो लैंड एक्विजिशन ऑफिसर का जो ऑर्डर है उसी की बात कर रहे हैं। दिस इज ए लैंड एक्विजिशन रेफरेंस by the land acquisition officer under section 30 of the land acquisition act और जबकि 18 में जो गया है, और वो सप्लीमेंट्री एफिडेविट हम इसीलिए फाइल किए, और भी कोर्ट से जो पूछे तभी फाइल किए, क्योंकि मेरे पास था, हमको दिया तो हम बोले जब इसमें चल रहा है कि 30 के कारण पावर आ रहा है इनको कि राइट टाइटल इंटरेस्ट यहीं से डिसाइड हो जाएगा, तो हम उसके लिए उसको फाइल किया जो कि 18 में ऐसा कुछ नहीं, वो कह रहा है कि अगर कुछ है वहां पे तो बताए, और वहां पे अवार्ड को भी रिफ्यूज कर रहे हैं देने से।
Reference made either under section 18 or 13 will have a force of degree that will be covered by the Patna High Court rules and regulations.
सप्लीमेंट्री देखा जा रहा है जो
Claim ही यही था हाफ शेयर, क्लेम ही यही था हाफ शेयर, क्वांटम पर तो कोई डिस्प्यूट ही नहीं है. There was no dispute on quantum. The dispute was only on the person on the share.
कहाँ पे देखें
आप ही के पिटीशन में देखें.
सप्लीमेंट्री में,
हाँ, आप ही के सप्लीमेंट्री में.
ये रेफरेंस तो 18 में है।
18 सेक्शन होने से क्या हुआ, वहाँ से लिखने से थोड़ी होता है. चलिए. WTC number 5375 of
एक
2012
जजमेंट था जो मेरे तरफ से,
for the learned counsel appearing on behalf of the parties.
अगर ये लगता है कहीं में,
क्या चीज़ के लिए आप लगा रहे हैं?
वो रिट कोर्ट में जुरिसडिक्शन के ऊपर था,
ठीक.
रेजुडी का तक।
The learned counsel for the petitioner has state है यहाँ पर. You have nothing to say. Last time also you had nothing to say.
No, no, sir. Counter has been filed and it has been stated that the main contest is between the petitioner and the private interest. However, in support, in counter it has been stated that the commissioner has passed the order taking into consideration the fact that the rent was paid by the appellant of that case, who is the respondent in the revisionary order, and on the basis of adverse possession.
Adverse possession, he has got the right to declare adverse possession.
But petition as the order has been filed, passed.
Does he have the jurisdiction to declare adverse possession?
But this was a stand taken in the review audit.
WPC number 5375 of 2012 for the learned counsel appearing on behalf of the parties. The learned counsel for the petitioner has referred to the order dated 21/2/2023 and has submitted that the entire arguments of the petition has been recorded therein. He has in particular referred to paragraph 3 to 7, right, which are quoted as under. The learned counsel has submitted that the learned counsel has placed the judgment passed by the subject Dunka under section 30 of the Land Acquisition Act, wherein there was a dispute with regard to declaration of apportionment between the present petitioners who are claiming through Sheikh Bikari and the private respondents who are claiming through Rasul Khan. The Learned Council has also referred to the sole point for determination in the state proceedings, which has been mentioned in paragraph 5 of the judgment as follows. Quote, the only point for determination in this reference case is that who was the legal heir of Zahurin Bibi, the recorded tenant. Zahur Jan Bibi, the recorded tenant. And he has submitted that the parties had contested the case and ultimately the finding was recorded in paragraph 16 thereof that the claimants are entitled for compensation money as indicated. Sheikh Ghafoor and other descendants of Sheikh Bikari are entitled to half of the compensation amount and half will go to the relation of Rasul Khan, the descendants of Alidad Khan. The finding in paragraph 16 is quoted as such. The Learned Council has submitted that the finding in the land acquisition proceeding between the parties with regard to the legal heirs and successors of recorded tenant Zahurzan Bibi is final and is binding on the parties. He has relied upon the judgment passed by Honorable Supreme Court reported in bracket 1952 bracket close 2 SCC 219 paragraph 15 and 16. Sorry, para 13 to 15 and also in the judgment passed by Honorable Full Bench of Patna High Court reported in bracket 1997 bracket close 1 PLJR 155 Full Bench para 40 and further the judgment passed in the case passed by Honorable Patna High Court reported in 1973 SCC Online Patna 123 para 7 and has submitted that the findings recorded in a proceeding under section 30 of Land Acquisition Act 1894 is binding on the parties. The Learned Council has again referred to the impugned judgment passed by the Commissioner and has stated that the Learned Commissioner could not have just brushed aside the findings recorded in the land acquisition proceeding and therefore the land involved in this case was to be also recorded in the name of the petitioners to the extent of 50% of the share. Counsel for the respondents, on the other hand, has opposed the prayer and has submitted that and has relied upon the judgment passed by Honorable Supreme Court reported in bracket 1979 bracket close 3 SCC 135 and has submitted that under Article 226 of the Constitution of India, the res judicata will not apply. He has further submitted that the present petition has been filed under Article 226 as well as 227 of the Constitution of India, and Article 227 has been wrongly invoked. The Learned Counsel has also submitted that the petitioner cannot challenge the order dated 7/1/1987 passed in 40 case number 31 of 86/87, as the order was already challenged before the Learned Commissioner in revision miscellaneous appeal number 27 of 1987-88, and recent order has been passed which is included in the present proceedings. It has also submitted that the petitioner has made a prayer that the entire land should be recorded in their name, although the private respondent cannot be excluded, as in terms of the argument of the appellant, they are only entitled to the extent of 50%. The Learned Counsel has also submitted that different genealogical table was prepared and submitted in the proceeding in the 40 case and LAR case. And therefore, Civil Court Dumka is the competent authority to decide as to who are the legal heirs and successors of Zamuzan Bibi, recorded tenant, if any such dispute occurs. And disputed questions of fact with regard to legal heirs of Zamuzan Bibi cannot be decided in writ proceedings. The Learned Counsel has further submitted that in the impugned judgment, in impugned order of the Commissioner has clearly observed that the petitioner could go to Civil Court for declaration of title, but in spite of such order, the petitioner has not chosen to go for such declaration. He submits that the 40 case was initiated on the premise that there was no legal heir and successors of Zamuzan Bibi, in which altogether 4 set of parties had participated, which ultimately resulted in an order passed in favor of the private respondent. The Learned Counsel has also submitted that record of rights is final after publication of after 6 months from the date of publication in terms of section 25 of the SPT Act. The Learned Counsel has submitted that in the 2 proceedings before the court case and the miscellaneous appeal, the claim of the petitioner were different. He has further submitted that in the writ petition, the petitioner did not mention as to under which section of the Land Acquisition Act the LAR case was referred by the subordinate judge. The Learned Counsel has submitted that he has brought on record the entire order sheet of the land acquisition proceedings, and on the first page of the order sheet, it has been mentioned that the land acquisition proceeding was referred under section 18 of the Land Acquisition Act, and therefore the recording in the judgment passed in LAR case number 2 of 83 within bracket annexure 1 to section 33 is incorrect. The Learned Counsel has also submitted that there has been further land acquired in the year 2004, and in that case the compensation amount was disbursed in favor of the private respondent number 11. He has also submitted that in the original Khatian, the name of respondent number 6 to 14 was inserted. And at the end, he has reiterated that disputed questions of facts cannot be decided under any jurisdiction. After hearing the learned counsel appearing on behalf of the parties, and upon going through the records of this case, this court finds that it is not in dispute that so far as the LAR case number 2 of 1983 is concerned, the petitioners, you are more than one? Or you are the only one? More than one. The petitioners and the private respondents / their predecessor in interest were parties. It is further not in dispute that the said proceeding was also in connection with Jamabandi number 20.
Yes.
Jamabandi number 20, which is the same Jamabandi which is involved in the present case. It is also not in dispute that the judgment passed in LAR case number 2 of 1983 has attained finality. The perusal of the judgment reveals that the point as to whether who is the legal heirs and successor of Zahurzan BP recorded tenant was the only point for determination. Apparently, both the parties were fighting with regard to apportionment of the amount under land acquisition proceedings. The judgment reveals that it was hotly contested between both the parties, and ultimately a finding has been recorded that both the parties were entitled to half share each. This court finds that the issue regarding legal heirs and successors of Zahurzan BB, the recorded tenant, was directly in issue in the proceeding in LAR case number 2 of 1983. The perusal of the judgment reveals that it was essentially a reference under section 30 of the Land Acquisition Act, as the parties were fighting with regard to apportionment of the award. The further facts reveal that the private respondent herein had also filed title appeal number 49 of 1986 against the judgment passed in LAR case number 2 of 1983, which was dismissed on 18/5/1990, and the judgment passed in LAR case number 2 of 1983 attained finality. This court finds that prior to passing of the final judgment in LAR case number 1983, which was decided only on 18/6/1986. A proceeding bearing fourth case number 31 of 1986 was initiated, and final order in the said proceedings was passed on 10/4/1986. In the said proceeding was initiated assuming that Zahuzan Bibi had died without leaving any heir, but the authority, after hearing the parties, was of the view that the private respondents hearing were the heirs and successors of Zahuzan Bibi, and accordingly directed for recording of the property in their name. Correct? The petitioners had filed a plea before the commissioner, in which was numbered as Revision Miscellaneous Appeal number 27 of 1987-88, and by that time the judgment in the land acquisition case number 2 of 1983 was pronounced, and consequently they relied upon the said judgment. But the learned commissioner not only refused to but the learned commissioner recorded that in certain proceedings, the manager of the Ganjo state, who was a deputy collector appointed by the deputy commissioner under the Court of Wards Act as zamindar of the state, was a lunatic. इसका तो क्या मतलब है? कहाँ पे इसको डील किया exactly?
The LAR case.
हाँ, yes,
Page
the
57.
appellate order.
Page 57.
However, the learned commissioner recorded that although the learned subordinate judge Dumka on 18/6/1986 declared half share of the property, but the amount of compensation could not be lifted by them as yet, because as per the collector's opinion is that unless the matter is finally disposed of in title suit, no money of compensation can be given to anybody, and the amount of compensation was still lying in the treasury. This court finds that such observation made by the learned commissioner is especially perverse in view of the fact that in the title suit, the issue regarding legal heirs and successors of Zahuzan Bibi was duly decided, and the same has got no relevance so far as the collecting of compensation from the concerned collector is concerned. Is concerned. From the collector is concerned. This court further finds that the learned commissioner further was of the view that the private respondents herein had perfected their title and unless it is reversed by a competent court of civil jurisdiction, no relief could be granted to the petitioners. This court is of the view that the learned commissioner had no jurisdiction to decide the point of adverse possession, and such point can only be decided by a competent court of civil jurisdiction. The learned commissioner exceeded his jurisdiction while recording such a finding and asking the petitioner to go to the competent court of civil jurisdiction to get such a finding reversed. The impugned judgment of the learned commissioner cannot be sustained on both the grounds. Firstly, the learned commissioner has wrongly ignored the judgment passed by the learned Sub-Judge Dunka in the land acquisition case number 2 of 1983, and further holding that the private respondents herein had perfected the title. And accordingly, the impugned order and accordingly both the impugned orders cannot be sustained in the eyes of law, which are hereby set aside. Both the impugned orders refusing any share to the petitioner, right? Refusing any share to the petitioner is hereby set aside, and it is held that the petitioners would be entitled to half share of the property, equivalent to that of that which has been conferred upon the private respondent herein. On the strength of the binding precedent between the parties, on the binding judgment between the parties passed in LA case number 2 of 1983. So far as the judgment which has been cited by the learned counsel for the private respondent reported in bracket 1979 bracket close 3 SSC 135 is concerned, the same has no applicability to the facts and circumstances of this case, in view of the fact that the said judgment was dealing with the point of res judicata between petitions under Article 226 and 32 of the Constitution of India. And it was held that where a petition under Article 226 is dismissed without a speaking order, such a dismissal would not constitute a bar of res judicata to a subsequent petition on the same cause of action. This court is of the view that the issue as to who would be the legal heirs and successors of Zauzan Bibi was directly in issue in LA case number 2 of 1983 and was hotly contested and decided. And therefore, any contrary, and therefore, the said the judgment which has been relied upon by the respondents otherwise also does not apply to the facts and circumstances of this case. और बाकी तो जजमेंट से सब पैराग्राफ कोट करते हैं.
Only one thing, it's a date 10/4/1986. The original order was passed on 26/5/1986.
26/5/1986.
1986.
So that was prior to the final
Prior
order.
to
26/5/1986. State का तो भूल ही गए थे. The learned counsel for the state has submitted that the learned commissioner has held that the private respondent had perfected their title by adverse possession and there is no illegality.
And it was paid back.
and rent was paid by them, and therefore there was no illegality in passing the improved judgment by the Learned Commission. आपको binding precedent पे कुछ बोलना है? So far as the point of res judicata is concerned,
On the last occasion litigation.
Huh.
So,
The submission is recorded.
that's why
she has submitted that her submissions have already been recorded on the point of res judicata in the order dated 23 to
Order number 20.
Order number 20. We take that. Writ petition is allowed in their proceedings.